All rise. The Court of Appeals Division 1 is now in session.
Good afternoon. You may be seated. We are here today in case number CV16 0097, Arizona Electric Power Co-op versus landowners. Each side will have 20 minutes. These proceedings are being both audio and video recorded, so we would ask that you identify yourself and your client the first time you approach the podium. We have read the briefs and conferenced this matter already, so if you'd keep that in mind with your argument when you're arguing, and with that, you may proceed.
Thank you, Your Honor. It's Dale Zeitlin for the appellants, defendants, property owners below. I'd like to begin by just focusing my remarks on Article 2, Section 17 of the Arizona Constitution and Hughes-Toole, the Supreme Court case out of the 60s. I did cite both of those in my briefs. I actually believe, Your Honors, that both the constitutional provision and Hughes-Toole are dispositive of the first issue before the court, which is whether the property owners, in this case, are entitled to, or let's say when a taking actually occurred. And that's kind of the first big issue in the case. We believe that the taking has not occurred, constitutional taking. We don't believe there's any common law claim for taking at whatsoever. It has to be based on the Constitution. So therefore, the rent, or we believe that there's a trespass or a holdover tendency, and that my clients are entitled to rent from the date that the limited term grant expired, which is basically just a lease below, which was in May 2011, May 14, I believe, 2011, until the date when a constitutional taking occurs, which will be when a final order of condemnation is entered in the case, which has not yet occurred. So let's go back to Article 2, Section 17, why I think it's pretty much clear and dispositive. And it has basically, the Arizona Constitution has two different phrases in it. The first phrase is general, and it applies to everyone, all potential condemnors, that property cannot be taken without compensation first being paid into court, and that can be paid by way of bond. The second part of the phrase, which is discussed at great length in Hughes-Toole, the Supreme Court case, has an exception for municipal corporations, but has very much limited the constitutional rights of private corporations, which the power company is in this case. And that is limited before any taking can occur under the Constitution. There has to be two criteria have to be met, and that is there has to be payment of full payment of full compensation, and full compensation has to be decided by a jury. Those two things have to happen under the Constitution before a taking can occur. And Hughes-Toole goes a great length. I'm sure you all have read it. It gets into it's unusual here in Arizona, it gets into the legislative history of Article 2, Section 17, and concludes that in that case, a utility company simply doesn't have power to take property until the payment, full compensation, and jury decides compensation. A little different,
though, in this case, since they were already there.
No, not whatsoever, because the question then is whether they're certainly there. I mean, no question about it. Right? No one argues that. The question is remedy, right? It's really kind of remedy. And so what the power company wants to do is they want to say, because we were there, that's a taking, and therefore we should get taking remedies. I submit that is not possible under the Constitution. That would be unconstitutional in this case. But I do, Judge McMurdy, I do want to say something on that score. So because there could be some confusion on this issue. Federal case law, which has been cited to your honors, is 100% different, or 180% different, polar opposite than Arizona law. Why is that? Because under the Fifth Amendment is not limiting on the federal government at all. So in a federal government takings, what the Fifth Amendment says, so now we don't have Article 2, Section 17, we just have the Fifth Amendment. The Fifth Amendment only says that private property for public use shall not be taken without just compensation. It doesn't say first, and it doesn't limit. There's this, there's, perhaps this is hyperbole, there may be thousands of federal court cases on this. I recall very clearly a great discussion, and I cited the case to your honors in Kirby Forest Industries by the U.S. Supreme Court, discussing the fact that the U.S. government doesn't even have to file a condemnation case ever. Never. All they have to do is enter property, bam, and it's an immediate taking of the property. It's an immediate taking. Just compensation can be paid later. And then there's all this federal court about, how you make that constitutional. There's an interest requirement when payment is made after entry.
Well, can I go back to Hughes Tool just briefly?
Yeah, sure.
This is a little bit different in that you're not really asking. In Hughes Tool, the request was to overturn the court's order granting immediate possession. And here the landowners aren't saying we want them off. They're acknowledging that this is going to go forward, and so they're in possession in the meantime. Whereas in Hughes, it was clear they were not entitled to be on the property at all. And here the landowners have said, essentially, okay, well, you can stay there, pay us some rent.
Right. That's
and
true.
It seems a little bit different anyway. I understand the principle. The court in Hughes clearly said you can't go forward. You're not entitled to possession. There isn't a taking until payment has been made, the valuation and payment.
Right. No, look, there's no question. They're in possession. Factually, it has that distinction. I certainly
in possession with the understanding that they're going to exercise their authority to.
No, I would not concede that point. So let's talk about the facts of the case. You
don't think they're going to pursue an eminent domain claim?
That it wasn't presumed that they would. It wasn't presumed. They eventually did.
You said when? At the time? You said they weren't going to presume. When? I mean, they're pursuing one now.
Right. I'm just saying, at the time the lease expired, I call it the lease. It's limited. Hopefully we can just call it a lease. At the time the limited term or the lease expired, there was no certainty that the power company would do anything. I mean, let's literally look at the facts that happened here. The land was in the federal government until roughly 1990. Okay, and under, we'll call it the lease. The lease expires in May 2011. Okay, let me just back up for a second. Let's assume that the power company wanted to stay there and wanted to properly exercise their power of condemnation, which they have. They could have filed the case any time before 2011, right? There was no impediment for them filing. They could have condemned the remaining term of the lease, or they could have simply, this is what I think should have happened, because they can't get a constitutional taking until a final order is entered, file the case in 2008 or 9 if you really intend to condemn. Because then, my point is, it's completely in the power company's control. The property owner can do nothing on this, right? We really can do nothing. Power company acts properly if they're intending to take.
You could have acted once the grant expired, right?
We did. We sent a letter to them telling them, advising that they were in trespass.
You could have taken court action.
Well, we didn't. We did by filing counterclaims, Your Honor.
Oh no, but that's not my point. Is there was a 3-year gap between the expiration of the grant and when you filed your counterclaim? I mean,
that's true. That's true.
You could have everything in your counterclaim. You could have immediately filed upon expiration of the grant.
We could have started charging them rent, but the statute of limitations hadn't run. We weren't obligated to do that.
I didn't say that, but you had claims. I mean, they were in adverse possession at that point.
No, oh, no. I don't think we necessarily had well, no, we certainly didn't have adverse possession claims,
Well,
because
they were
adverse
using the-
possession would last maybe 10 years. We had perhaps a claim for ejectment, and we had a claim for rent, for holdover rent. That's what our claims were. And we brought those in a timely fashion. There's no latches argument that's been made. There's no statute of limitations argument. But my point is getting back to the power company. Look at the power company. My only point is, had the power to condemn during the term of the grant. Okay, so they didn't do that. Grant expires in 2011. What happens? Power company uses the property for free. For free. They're not paying the lease anymore to the federal government or to us because the grant's expired. They don't come to the property and say, gee, we should pay rent. They're just getting away with it. They're getting away with using the property for nothing. We sent them a letter in January 2013 putting on notice on trespass. What did they do? Nothing. I mean, literally, those are the facts. They do nothing. And they don't file a case, a condemnation case, until a year later in 2014, which gets to the point, and here's the basic, what I think the basic point is, and it's kind of an election of remedies case, I believe. And actually, if you look at, I believe, all of the cases, that's a bit hyperbole, many of the cases that deal with an expiring lease with a holdover tenant that's a federal government, maybe even a state government, but certainly in the federal government situation, the courts, and I've cited those cases to your honor, and the Allenfield case is a great case in the federal court of claims case that says the remedy, actually the Allenfield case, and I urge you to really look at it carefully because I think it's on all squares on this case, because what in the federal court of claims, this, is like the super judicial panel on inverse condemnation cases. Under the Tucker Act, every inverse condemnation case goes before the federal court of claims. So this issue came up. It was a U.S. government under a lease expires, they hold over. And the issue was, is this an inverse case, a takings case, or is it a contract case? Do you get reasonable rent? That was the issue. And the court said both claims are viable. Both claims are viable. Both a takings claim and a claim for rent. The court, and this is really interesting, this is why I think it's on all squares. Allenfield said they're both viable claims, but the common law claim is the better claim. It's the better claim because we really should reserve takings claims for unique situations where there's no other remedies available at all. Here we have another remedy, just common law, plain old rent. That's what every holdover tenant would have to do. The power companies are no different shoes, Your Honors. That's the whole point. There is no special rule that protects the power company from plain old common law holdover rent. And that's all we're asking for, Your Honor, in this case. The cases, and I will say this, the federal cases, again, when that distinguish that, which the appellees have properly cited, talk about a holdover rent in conjunction with a declaration of taking filed in federal court. You go, okay, that's kind of similar here, but it's not similar at all because the declaration of taking there's no other act under the Fifth Amendment. In other words, that's the final taking. So there was a holdover rent, and the federal government simply by possession is a constitutional taking. That's the big difference here, Your Honors. I'll withhold some of my time. Well, I do want to touch on the improvement issue and a little bit. And again, I really think this whole case is governed by common law rent principles. And in here,
Didn't the lease in this case contemplate that
I'm sorry, Your Honor, which case?
Didn't the lease in this case contemplate that the physical, that the power lines or whatever would remain the property of the utility company?
So I don't believe so. I don't believe so. So this is.
It's supposed to remove them at the end of the lease?
So first of all, the lease itself, my recollection, Your Honor, the lease itself was silent. I don't believe it really said anything about the removal or ownership of the improvements. That's my recollection. If I'm wrong, I apologize to you all. I believe it's found, the issues are found in the Code of Federal Regulations, which are, I guess, maybe part of the lease, if you will. I'm not 100% sure if that's the right way to say it. And the Code of Federal Regulations do say that a lessee, if you will, has a right to remove those improvements at the end of the lease. No.
So is there any question that if this were still land owned by the government, that the power company would be entitled to remove the?
Oh, yes. Under these facts, absolutely. Because under the CFR,
why are you different? If they're a holdover tenant, then why does that change the analysis?
Well, the analysis, I think, is actually the same in this respect. The CFR gives the tenant, if you will, the lessee, the right to remove the improvements. But it takes away that right, if you look at the CFRs, when certain things happen, all of which happened here. It takes away that right if the tenant doesn't pay rent within 30 days.
But here you're asking for rent as one of the remedies. If you get rent, then are you entitled to the
But they haven't paid the rent. Under the CFRs, when
are
rent hasn't...
Are you going to drop your claim for rent then if you're entitled to keep the power lines?
No, we're not. But here's the point. We're not at all. Because I think this, under the CFRs, it was incumbent upon the lessee to continue paying rent during the holdover period. If they don't pay rent, and there's a specific clause on this, for 90 days, they being the lessee, 100% loses the right to remove the improvements. That's the reasonable expectation. Had this been continued to own by the federal government under these facts, and had the lessee under these facts not paid rent for 90 days, they lose the right to those improvements, regardless of whether the government claims rent and claims back rent. They simply lose the right. They are prohibited from removing those improvements. And I just want to say that the CFRs, I really just believe, codify Arizona law. That's all that, when you really think about it, and I cited the Russell v. Golden Rule case, a case I love the name of, but it was Golden Rule Mining Company. I don't know if that's kind of a oxymoron or something. I don't know. But the common law rule on a holdover tenant is if you don't pay rent within a reasonable time or get off the premises in a reasonable period of time, you forfeit your right to the improvements. It's that simple. That's a Supreme Court case. I think it was early, like 1960s, not that early, but anyway. So I think we have a marriage of this. I get back to here's the basic point. I think the reasonable expectation of any lessee, whether it's on the federal land or just a regular old tenant on a shopping center lease, is if you have some time to remove the improvements. If you don't remove them, you lose them. If you don't pay rent and the holdover, you lose them. You just don't have the right to it anymore. And those are ubiquitous common law principles, Your Honors, and I think they apply here. I know it might seem unfair to the power company. I certainly understand that. But the question is, why the heck did the power company not pay any rent when it was holding over for 3 years? And let's say this, they haven't paid a nickel of rent for 8 years.
But now if you assume you get rent and you get back rent plus interest, doesn't that take care of your concern?
It certainly helps. It certainly helps, Your Honor. I wouldn't deny that. I'm not sure that's the principle of the law, but it certainly would help. So I'll reserve the last 2 minutes. Thank you.
Good afternoon. May it please the court. My name is Charles Workin. I represent the Arizona Electric Power Cooperative, who is the appellee and cross appellant in this case. I will try to simply refer to my client as APCO. I agree with Mr. Zeitlin that the first issue here is when is there a constitutional taking? But after that is where we diverge. I think we need to keep in mind what is a constitutional taking. Well, a taking is an interference with property, an interference with the use of property or an interference with the value of property. I submit to you that a taking occurred in this case by definition when APCO remained in possession of the property after this right-of-way grant expired.
Why can't we just refer to them as a holdover tenant at that point? What have they taken that's different? They were a tenant, they were leasing, they had a right of way, they're supposed to be paying for it. It seems to me they're a holdover tenant unless they express a desire to exercise their right to eminent domain. It seems like it's just as logical to call them a holdover tenant.
I think the distinction here is that we're dealing with a, quote, tenant that has the power of eminent domain.
But do we know for certain that couldn't the electric company have decided we're going to go elsewhere? If these landowners want too much money, if there's going to be a development here, we can run our lines somewhere else. Why is it necessarily evident that that they're going to exercise their power of an eminent domain to take this particular land?
Well, I think one could infer from the facts that they invested in these improvements that had a lifespan of some 60 years, and they were only 30 years into that lifespan, and they're in the business of transmitting electrical power. It's unlikely that they're going to do anything other than stay there. So, but the owners argue that there is no taking.
Until they actually filed, there's nothing that would evidence that that was clearly their intent.
But nevertheless, there was an interference with the owner's use and value of the land.
How's that?
By the mere fact that the power company is still there in possession of the land.
I'm assuming it was there when they got the land. I mean,
yes, but
nothing changed.
The
lines were still there. You were using the lines. There was no. How did it interfere with the owner's use and enjoyment of the land?
But well, I think it's as a matter of law. When the owners acquired title to the property, the power company's use of the land was permissive. It was pursuant to this right-of-way grant. But when that expired, that permission went away, and they were then there. They remained in possession without benefit of that right-of-way grant, and they still had their structures there on the property. It is a possession of the land. The possession is in itself.
The answer to my question is, how did it interfere with their use and enjoyment? Did you ever block them from? I mean, there was nothing in this record that I could find that would indicate that there was an interference with their use and enjoyment, other than they didn't get the rent.
Well, sir, Your Honor, by legal definition, it's an interference. It doesn't have to be a physical interference in the sense of putting up a fence or blocking them or excluding them in some fashion. And I believe that I have cited case law and quoted case law to that effect somewhere in these voluminous briefs.
What's your response, though, to the provision in the Arizona Constitution that says the right-of-way shall not be appropriated until there's been evaluation and payment has been made? Doesn't that necessarily, when you couple that with Hughes' tool, doesn't that tell us that the electric company is there under some other authority than as there has not yet been a taking? I'm glad you got to that because I'm glad you asked that because I was about to get there. There is a taking when there is an interference with the use. This phrase, constitutional taking, is being applied to. But that's only because they have the authority of eminent domain? Let's say it's just a.
Yes.
But without that, there's someone who's there and is just a holdover tenant. Let's say it's some company that doesn't have they were just granted an easement, they're using their easement. They're certainly not a taking when they just keep using their easement. They're a holdover tenant or lessee or whatever we're going to call them. It doesn't necessarily turn it into a taking by them overstaying their lease.
I agree if we were talking about someone other than with the power of eminent domain, but this electrical company has that power. And a constitutional taking is not limited to the means, the procedures that are prescribed in Constitution Article 2, Section 17. Our case law is full of cases in which there has been an interference with someone's right, someone's use of properties, with the value of their property, and this court has referred to it as a constitutional taking. It's an interference. It doesn't have to follow these procedures.
What are we to make, though, of Hughes Tool, where the Supreme Court reverses the Superior Court's order granting possession? So the court had granted them possession. They're in possession pursuant to a court order, and the Arizona Supreme Court says, no, there's not a taking until you comply with the provisions of the Arizona Constitution.
Because, as you said earlier, Your Honor, in that case, there was an order of immediate possession granted by the Superior Court, and a private corporation under those circumstances isn't eligible for such an order. You know, here we have an entity with the power of eminent domain that simply stayed in possession and exercised domain over the property. And that constitutes a taking, and it is a constitutional taking because it affects an interference with the use or value of the property, by legal definition, I submit. And so you don't have to go through the procedural steps pursuant to Constitution or statute in order to effect that sort of constitutional injury for which the owner is entitled to recover compensation. In fact, it gives the owner the right to sue for inverse condemnation because there was an interference.
Are there any cases where there's been inverse condemnation when it's a non-governmental condemning authority?
I know of none, and I can't imagine that there would be, because I don't think private landowners inversely condemn the property of other private landowners, if I understood your question.
Well, I'm just saying, say it's a utility company like this that's not a city-owned utility where you have to proceed under the under subsection 2 in the constitutional provision. That no right of way. You're not a municipal corporation. You're a private corporation, and I'm just wondering, has it ever come up where the private landowner has challenged this private corporation that has the authority of to exercise eminent domain? Are there any cases?
Off the top of my head, Judge, I can't think of one, but there.
But you're saying the landowners in this case could have pursued an inverse condemnation?
Absolutely, and I believe that that's been agreed. It certainly hasn't been disputed in the briefing. We have asserted that they had the right to sue for inverse condemnation, and they did not. No one has argued that they did not have that right. So, and they had that right because of our exercise of domain over the property remaining in
but you agree they also had the right to sue for whether it's trespass or as a holdover tenant to come up with some sort of lease payment that's owed for remaining on the property after the lease expired?
Well, first of all,
I'm just trying to get it. Was that their only remedy? Do you think they had to file an inverse condemnation action?
Not necessarily. Now, they couldn't have sued on a lease because there was none. They couldn't have sued on the right-of-way grant because they weren't a party to it. It wasn't assigned to them. Title was simply transferred to them. They became the owners, subject to this right-of-way grant. When it expired, then they had, a holdover or a trespasser or whatever you want to call them, and they could have brought some action.
If they do that, does that automatically turn your client into does it create a taking just by virtue when they file a claim for trespass?
You can't avoid the fact that there's a taking by suing instead for something other than inverse condemnation, because there was, by definition, a taking. And if they chose not to, and we believe they chose not to for strategic reasons, as discussed in my brief, that doesn't change the fact that there was a taking.
Let's talk strategic reasons. What is your response to their suggestion that your client simply could have started these proceedings before the expiration of the lease if that was the intent, was to continue? It was entirely within your client's control what the ultimate valuation date would be.
Well, no, I think my client did control the valuation date. by effecting a taking the day after the right-of-way expired, remaining in possession, and then the valuation is made as of the date of the taking. So my client didn't need to do anything more. Could they have filed suit before?
Didn't need to do anything more and didn't need to pay any rent or do anything at that point?
The fact that they didn't start paying rent doesn't mean that they wouldn't later be entitled to rent if any rent was due. But because the taking occurred the day that after the right-of-way expired, the valuation is as of that date. They don't get the value of the property plus rent. They get the value of the property plus interest on that value. So rent is really shouldn't be in the equation here. And the reason that appellants are arguing for a later taking date is because they want a period of rent, during which time they also want to argue that the property appreciated in value, so they get a higher valuation as of whatever the valuation date might be. That's the strategy here.
But from our perspective, it wouldn't matter if the land could be going down in value.
It could.
For all we know. And we're just trying to determine how to apply this constitutional provision. And if it means that the valuation date is when payment is made, or if it means the taking occurs when payment is made, then it just depends on whether the market has gone up or down. And it's not really, it's neither here nor there in terms of our analysis of the argument. Would you agree with that?
Except that choosing a later valuation date, such as the time of trial, opens these proceedings up to some gamesmanship, where parties are trying to accelerate or delay proceedings to take advantage of a falling or rising market. You know, there's something else I discussed in my brief.
And don't courts have inherent authority to help move cases along?
Of course they do, but we can just eliminate all that nonsense by simply deciding that valuation occurs as of the time of taking. Taking occurs when there's an exercise of interference with the use or value of property. And, you know, the procedure contemplated by the Arizona Constitution simply doesn't matter to this case.
We just ignore the Constitution.
Well, I think it's a fine document, but it doesn't have application here. I'm not saying ignore it. That sounds that carries the wrong
arguing.
I didn't mean that connotation, Your Honor. I'm arguing to you that it does not apply in these circumstances, because the only way to effect a constitutional taking is this is not the only way to do that. This provision, you can effect a taking by an entity with power of eminent domain interfering with a private property owner's property. And, you know, there are lots of cases where...
So in Hughes Tool, if they had just gone on the property without getting a court order, then they were already there, and the result would have been different in your view?
It could have been. I think it would have been, but let's think about another alternative here, and that is, although this entity could not get an order of immediate possession, they later got an injunction that was effectively the equal of that. After the suit had been filed, they got an injunction that precluded the owner's interference with their use of the property and that allowed their access onto the property, the power company's access. And so that injunction is arguably another taking, in effect, although later in time than when the right-of-way expired. And, you know, it could be viewed at that time as a taking, and then the valuation would occur at that point in time, and rent would only be up until that point in time. We have 4 dates before you to choose. There is the date of the day after the expiration of the right-of-way. There was a taking. The court says, the trial court said that at the time of the summons there was a taking. Thirdly, the date of the injunction that followed shortly after the filing of suit could be a taking, or the extreme is someday in the future.
But the extreme seems to be what's contemplated under the Constitution. Where do we get those two middle, your two middle ground positions if we're trying to interpret the Constitution to say shall not be appropriated until full compensation has first been made in money?
I'm arguing that is not exclusive, because
No right-of-way shall be appropriated to the use of any corporation other than municipal until
Yes.
full compensation.
If you're going to
is paid.
proceed in the typical fashion, that's how it works. This is not the typical case, and the course taken here is
This is no right-of-way in the typical case shall be appropriated? Isn't that pretty much a blanket statement? No right-of-way shall be appropriated other than municipal until full compensation. I'm not reading in the typical case language in there.
Your Honor, I refer you to the cases cited and quoted in my brief to support the proposition that is, I believe, solid, that a taking occurs when there's interference. And there are multiple cases in this state and elsewhere where the constitutional taking is not limited to a procedure. It's a substantive analysis, not a procedural analysis.
So when it involves a non-municipal corporation, there are multiple cases?
I don't think that's on point, Your Honor, because, we have government entities that can affect properties in different ways that constitute a constitutional taking. And, here that there was a taking by remaining in possession. So in the time that I have, I'd like to quickly move to the ownership of the structures and lines. And by the way, there's no triable question of fact here about this. It wasn't argued below. The owners moved for summary judgment on whether or not the lines and structures should be included in valuation. They contended the facts were undisputed. Nobody disputed the facts. The opening brief doesn't argue a fact issue, and it wasn't until the reply brief that owners suggest that there's some fact issue. The federal regulations, as you recognize, Judge Catani recognized that the ownership of these improvements would remain with the power company, that they could have been removed, and by other analysis, they are trade fixtures that under common law could be removed. And there's been no forfeiture of those improvements. There certainly was no abandonment of them because the power company stayed in possession and continued to use them. And the fact that they weren't paying rent doesn't constitute a forfeiture. They're being sued for rent. And as the judge in Mohave County said, they seem to be taking inconsistent positions and should be collaterally estopped. And by the way, the regs have been argued in this business about failure to pay rent for 90 days affects a forfeiture of the improvements. I find support for that nowhere in the regulations, but it doesn't matter because the owners have conceded that the regulations do not apply as between them and the power company. And you can find that a citation to a transcript in my brief at page 28, and there were other locations in the transcripts as well where the same concession was made. So I have 1 minute left and welcome any further questions. Thank you all.
Thank you.
Thank you, Your Honors. Article 2, Section 17 is not procedural. It's fundamental rights. And the Constitution is a limitation of governmental powers. It's a reservation to people of power that's not taken from them. Article 2, Section, it's just simply not procedural. And to cast it asunder as a procedural something or other undermines the Constitution. And that's kind of where I started. The whole argument from the power company undermines the Constitution here. And Hughes Tool, and I'm glad, Judge Catani, brought this up. I mean, Hughes Tool was a much more favorable case to the power company. The power company actually tried to operate under the operation of law. They applied properly to the court for an order. They did things the way lawyers and judges, where we should do things. if you can get around Hughes' tool, I mean, this case, again, say, okay, it's it confined to these facts. My gosh, what the power company suggests is a roadmap for every private utility company doing away with the Constitution. They don't ever have to follow the Constitution. Never. All they have to do, let's forget the orderly way to do it. Let's just race out on somebody's property and put something on it. Put a power line on it. Put a sewer line on it. Put a water
They're
line on
suggesting
it.
there's a difference when there was an agreement that the lines would be there. There was actually a lease, and now it's obvious they have the power of eminent domain, so it's not quite as blatant as perhaps I was suggesting. They didn't come in and trespass and.
Yes, I understand that, Your Honor, but I'm just saying there's a factual difference. I certainly concede that. There's not a constitutional difference, Your Honor. That's the whole point. So thank you very much.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we're adjourned.